morning or good afternoon, everyone. I'm Charina Garcia, and I'm the Strategy and Immigration Partner here at WR Immigration. I'd like to welcome you to our Chatting with Charlie series. This webinar is specifically for employment base, and Charlie will be discussing his predictions as it relates to the Visa Bulletin and its movement or lack of movement. Charlie leads our government relations group. He was the chief of State Department's Visa Control Unit for 23 years, and he directed all the numerically controlled immigrant visas. We also have Laura here, and she's our senior associate, and she's going to discuss what's on the top of mind of many of our global mobility managers. With that, we can move to the next slide. So this is just our standard legal disclaimer. We welcome you to reach out to us if you have any questions or would like to schedule a consultation with one of our attorneys. And then, of course, our presenters. So Charlie, Laura, why don't you give them a warm welcome?
Hello, it's great to be with everybody today.
Excited to be back.
Yay. Next slide. At WR Immigration, we pride ourselves on journeying forward with our clients. We have over 9 offices globally and continue to grow with over 200 professionals. So if you want more information about our firm, we invite you to also reach out. So today's roadmap, what we're going to do is we're going to kind of deviate from what we've done before, and we're going to spend half the time talking about the Visa Bulletin, the December Visa Bulletin and the trends. We're going to spend more time, and then also about the employment-based and family-based final action predictions, but we're going to spend more time on the Q&A that we've received, and then also any that we received today while we're live in the program. So
I see questions already coming in.
I know.
So yeah, go ahead and
we
go
see
ahead
the
and drop
questions.
them
Go ahead and drop them in there, and Laura's going to be handling the question portion of this webinar. So Charlie, can you talk to us about the employment-based dates for filing and whether we're going to see some movement? And this is the dates that you're eligible to file with the USCIS, correct?
Right. Excuse me. Yeah, and these are the Chart B dates. There is no change in these dates. These dates were established in October based on consultations between the State Department and USCIS, and they established these dates based on their desire to produce enough future demand by applicants using them to file, to use all the available numbers during fiscal 2024. So I would not expect any movement in these dates until probably the middle part of fiscal 2024.
Okay, so next month's Visa Bulletin will probably still have the same dates for filing. So you don't have to drop everything you're doing to file that adjustment right away. You have a little bit of flexibility.
Well, it is important to use the Chart B for filing, because the Immigration Service will make a determination whether they will allow Chart B to be used for adjustment of status filings, and they do that on a monthly basis.
Okay.
In the past few years, they've allowed them to be used until sometime between January and March.
Okay, so it's a good idea to get all your documents ready in case there's some movement here in the dates for filing. Let's go to the next slide. So let's talk about all chargeability countries, Charlie. So for the December Visa Bulletin for the final action dates, we didn't see any changes. Can you please enlighten us on what's going on here and why there's no movement?
Yes, and these will apply to when we discuss the China and India as well. I think that the State Department is a little, in their terms of moving the dates, they may be a little bit gun shy based on the issues of multiple retrogressions during fiscal 2023 and also retrogressions which occurred in 2022. So it appears that they've held virtually all of the employment dates for the first quarter, and I believe they've done so in order to get a firm handle on number use during the first quarter. As I mentioned last month, they have the demand in, if they move the dates, they know that they have visibility into the demand. So even though they may not be reaching their desired number use so far, they know they have the remaining 9 months to advance the dates. They know they have the demand there, and they can start after the for the January on. Hopefully, they will begin advancing the final action dates.
So they're taking it slow right now.
Taking it
Taking it
slow just to make
Okay.
sure they're in, it's always good. They could be 1,000 numbers under their desired limit, but they've got, 20,000 numbers by moving the date. So it's not a big deal. And those cases are essentially pre-adjudicated, ready for scheduling for interview at an overseas post or final action at USCIS. So it's not a problem in allowing all the numbers to be used. And again, I think they want to avoid retrogressions this fiscal year at all costs.
And the next chart we have is about China. So we don't see movement in EB1, but we do see a little bit of movement in EB2 and EB3. So last month you gave some predictions on what you thought the movement would be in China or India. Were you spot on?
First preference didn't move. I'm a little surprised. The date was current until last December, and then after that, it was February 1st of 2022 through the end of the fiscal year. So the current date at February 15th of 2022, most of those cases should have been able to have been processed last fiscal year. So again, they may be just waiting to stockpile some extra numbers in case there's sudden influx of cases with early priority dates. In the second and third, second preference, I predicted 1 week movement. It was a 3-week movement. I predicted third preference, a 3-week movement, and it was a 3-week forward movement. So I would expect in China second and third that you can expect the dates to continue to move. And for January, I would hope and expect the China first preference to also advance.
Great. So let's move on to India. And unfortunately here, we haven't seen any movement in November and December. So can you tell us about that?
Yeah, these are the dates I'm most surprised at. For the employment first preference, the category was current for 21 months. It was current, or the date was before February 1st of 2022. So even though there is an extremely low per country limit this year, I'm a little surprised why they cannot advance the date beyond 2017, given the fact that there should not be much, if any, demand by Chinese applicants with earlier priority dates that had not been previously processed in earlier years, unless there was an unknown backlog that was unannounced.
Because they rolled it back in August, all the way back from 2012 to, from 2022 to 2012. And then they moved up in October to 2017.
Yeah,
so do you think they'll get up to 2022 soon?
I think that like I said, I'm extremely surprised given the fact that they are covering dates that should have been processed years and years ago. Where is this demand that is preventing the forward movement of the China or the India first preference date?
Well, Laura may have an answer to that, because if they're have an old priority date and then they've been moved to EB1, right, Laura, then that's probably why there's an influx of filings.
Yeah, I think for the EB1, that makes sense that there's folks with pre-existing priority dates that have now qualified because of a rotation abroad as a multinational manager, or they've gone back to school, got a PhD, or for whatever other reason, they're working patents or innovative industries, they can qualify for EB1. So that one, I can understand that folks might have these really early priority dates like 2012, and then now jump the line for EB1. I think it's more difficult to explain the just lack of movement in EB2 and EB3 and why
Yeah.
those dates just have not moved. And that's difficult to explain to clients, and also disheartening to explain when someone who's starting the process, predicting the length of their potential wait time to receive a green card.
Yeah, it's tough to tell clients, when I first started my career, 4 to 6 year wait, and then now 6 to 8, 8 to 10, and now possibly 10 to 12. So it's a really difficult discussion to have. And Charlie, is that really what we're seeing in terms of this movement?
Yeah, on India employment second preference, again, I've mentioned, last fiscal year, including the initial date, there were 3 retrogressions of the India employment second. The State Department and USCIS truly wants to avoid such volatility in the movement of the dates. It's devastating probably for your clients. It's equally disheartening for both USCIS and DOS in terms of their processing. But I have to admit the current January 1st, 2012 priority date or final action date, the final action date was well beyond that for an entire year, during which over 55,000 Indian second preference visas were used. So that would indicate to me that during that period when there was a much later final action date, which reached into late 2014, that it would kind of indicate maybe cases were not being processed in a first in, first out basis, that they were adjudicating and finalizing action on those cases which had 2014 priority dates at the expense maybe of those with earlier dates. The other possibility is if applicants are upgrading from EB3 to EB2 status, that will also put, as Laura mentioned, EB2 is going to EB1, which I really hadn't thought about until she mentioned it. The EB3s to EB2s could be putting a strain on the EB2 category as well. And we will see that anytime there is a category where the applicants will have been sitting in the line waiting for an extended period of time, they will gain expertise, which may allow them to increase, go to a better category. They're more likely to expand their potential case size. They acquire spouses or additional dependent children, which, and each of them uses a number, which also, limits the availability. I mean, if the case size goes from, 1.5 per case average to 3, that's a big change.
Yeah, so you're basically saying the 140,000 numbers that are allocated for employment base, that's the principal and also their dependents.
Yeah, every applicant counts against the annual limit. And again, the longer the case is sitting there, the case size is likely to get larger.
All right, so let's talk about your predictions for forward movement. So can you walk us through these?
Yeah, I would think, unfortunately, for the most part, they didn't prove to be correct for December movements, but I really expect these movements, in the future, once the department begins to advance the dates. And I mean, I see no reason why these shouldn't, occur. And it's possible, if they hold and they hold and they hold, they may advance the date multiple, even greater than I had expected.
Hopefully by years versus
I don't think they're going to do it by years, but for example, in the India first preference where 1 to 2 months, could they advance it, 2 to 4 months? Because they're saying, okay, we didn't move it for the first quarter. We are way under our number use target for the first quarter. We don't think we're going to get the additional demand. We feel comfortable starting to advance the date and work off some of that pending waiting list.
And you've said previously that we may see more movement January to March.
Yeah, is like I said, as they go into the second quarter, when they get ready to do the January dates, they should have a really good idea how number use for October and November compared to what their targeted number use. So they should begin to be able to feel much better. And the Immigration Service will have a much better idea that how many applicants are filing based on the application filing dates, which were announced in October. If they had estimated, say, for example, that 10,000 applicants were going to be filing and only 3,000 have filed, then they can feel a little more comfortable. Okay, there's not going to be as much stress on the number demands, so that we will feel better if state starts advancing things.
Okay, so we'll have to stay tuned to next month's Visa Bulletin for January. So we can move to the next slide. We get a lot of questions about EB3 all chargeability, because that's actually where a lot of our healthcare workers sit. And there is a proposed bill that's out there with the Senate Healthcare Workforce Resilience Act. It would permit up to 25,000 nurses and 15,000 physicians to receive unused visas, and then expedite the visa processing and require employers to prove that they're hiring a foreign national nurse or physician that's not going to displace a qualified U.S. worker. This is all proposed. So Charlie, what are your thoughts on this?
Well, this proposal is similar to the Real ID Act of 2005, which recaptured 50,000 unused employment numbers for use by Schedule A workers. That did so at that time, applicants had one shot at a number under the normal third preference limit, and then they had a second shot at a number based on the use of these recaptured numbers. So they had two chances each month. I can tell you this bill was proposed, I believe, in sometime in 2001, or excuse me, 2021, I believe, during the summer. I remember commenting on this type of bill, and this bill went nowhere at that time. So whether it has potential to proceed this year, I don't know. I really don't expect any bills on immigration to go anywhere during an election year. That typically is not a good time to introduce any changes to immigration reform, like I said, during an election year.
Okay. Now let's talk about family base, because there's a lot of questions going around about what's happening with the family base dates for filing and final action dates.
Yeah, if I sounded down on the employment movements, I'm even more a little confused on the family side. None of the rest of world dates have advanced more than a total of 6 weeks during the last 2.25 years. For example, the family first has moved 1 month in 2.25 years. The F2B category, that's the sons and daughters of legal permanent residents, that has not moved a single day in the last 2.5 years. The State Department processes approximately 95% of the family-sponsored cases. The COVID impact on overseas processing was devastating, but I believe by 2022, late 2022, and throughout 2023, those backlogs should have been able to be addressed sufficiently to allow forward movement of the family dates. The other thing that's a little concerning, despite the lack of forward movement, there were 21,000 unused family numbers under the 2023 annual limit. That was a huge benefit for the employment categories in 2024, but those numbers are lost forever to family-sponsored applicants.
Wow. So dates for filing, you predict will stay the same,
Yes.
no movement. And then the final action dates, the next slide.
Yeah, that's what I was speaking mainly
Yeah.
on in for the families. So again, I don't understand why there hasn't been movement, and I truly would expect the rest of world dates to begin forward movement.
And so the next slide just kind of summarizes again what you've said, right? Okay, so now we're going to move on to questions. So I'll let well, I'll ask Laura a couple of questions first, and then she can take
Sure.
over and ask Charlie. So the last two bullets here, do you have any data on how many I-485 applications are pending with USCIS, Laura?
So no, USCIS does not disclose this information. In fact, I think last month when Charlie was discussing predictions about how long will it take to receive a green card, USCIS doesn't post how many I-140 applications are pending, nor do they post how many I-485 applications are pending. So this is unknowable. And that's why we're also sort of pointing to, Charlie mentioning like some reasons potentially why EB2 or EB3 India didn't advance is perhaps there's not been a first in, first out or sort of priority date order of issuance of I-485s back in 2020 for EB2, EB3 India. So this is just not known, unfortunately.
Okay, and then are companies revisiting their green card sponsorship policies?
So this is a question I know that we've both been getting from our clients, just to take a market pulse and temperature of what's happening in light of layoffs. So companies are really looking for cost containment in light of layoffs. I think some of the things that I'm seeing companies do is remove support for dependents. That's largely in the non-immigrant visa space, that if they had supported in the past, they're revisiting those costs. We are seeing some companies that had taken a really aggressive sponsorship approach, like within 30 days of hire to initiate green cards. We're having those companies delay for maybe 6 months tenure, which 6-month tenure generally is the sort of average. So they're sort of regressing to the average companies that had previously been really aggressive.
Okay, we're just going to move to the question and answer.
Why don't I take some of the live questions? There was a really good one I liked that was relevant to our discussion about Charlie's prediction for movement in Q2 or Q3. And this question is from someone online here. With slow movement in the dates, is there risk that visa wastage given that USCIS processing time is not the best? So if dates move later part of the year, but both agencies are not able to process the new applications before the end of the fiscal year, how does that play out?
I don't think that is a concern, and it is one of the, if there is a good aspect of a date retrogressing, it is the fact that petitions would have been filed with the Immigration Service. The Immigration Service or State Department may have acted on those, and they may be in the pending demand file. So the State Department, for example, in the India second preference, I mentioned that the date had gone out to 2014 at one point. People would have filed based on that. The Immigration Service may have been processing the case by the time they had done all the required processing and submitted a request for visa authorization to the State Department. The date may have retrogressed. So the State Department would hold that request for a visa number until whenever in the future it becomes available. And if the date advances, then the State Department would send an email message, for example, to the Washington District Office and say that India applicant A number 1234 with a priority date of this has been authorized a visa number for the month of January. The officer at the Washington District Office could print that out, stick it in the applicant's case file, ship it off to get a green card produced. So with all of that pending demand out there, it's very easy to make use of numbers in the future. When I was chief, I would often hold the India second preference date even though I knew I had numbers, there was some concern about the influx of new filings. So I would often hold the India second preference date until the summer months and advise the Immigration Service, I am likely to move the date to X in July and beyond. Start prepping these cases if they need to have any updates on clearances or anything else, given the fact that I'm likely to move the date at that time when I feel more comfortable, then I'm not going to get blindsided by, earlier dates. So again, I don't see after this long ramble, I don't see any problem with the employment limits being maximized in any of the categories during fiscal 2024, even if
Okay,
even if the dates didn't move until the summer.
okay, because it sounds like it's more about the action of like reserving the number than it is finalizing the adjudication.
Right. And
Okay.
it's a very good process. I mean, immigration can request the number, and like I say, the State Department will hold it in their pending demand file until a visa number is available based on the forward movement of the dates.
I think where it gets tricky, and maybe Charina can comment on this, I'm calling you out on this. The cases for those Indian EB2 or EB3 cases that may have been filed in October of 2020, but still haven't been adjudicated, those ones I think could be kind of hairy to adjudicate. Like if the number advances this summer, like those ones are going to be the difficult case, could be the difficult cases because they might have expired medicals, they might not have filed with medicals. Those are going to be more complicated and probably why USCIS maybe potentially hypothetically didn't get to them initially.
Yeah, I mean, there was a question in the live chat about, there's a rumor that they will process the newer cases first over the older cases. And I think there's some validity to that, and just in what we've been seeing, right? Because the October 2020 cases are older and they may have to get the medicals done. Because I know many of our 2020 cases, we did not submit medicals. And then they
Right.
also have been sending many of these adjustment cases still to the field offices because they don't have enough staffing in the service centers to handle it. And so you also have to deal with the local offices and their ability to process these cases as well. And we're seeing like adjudication that's not normal, to be honest with you, when it's coming out of the local office. And we're having to, talk to them and explain to them, and try and figure out, how can we get these cases approved quickly? Because they are, I mean, my eyes are stale. They've been there for a long time.
Yeah, totally.
And from our point of view, like what we're telling our clients is if you can reach out to us, and we have Joey Barnett that will file a mandamus and things like that. So if you really feel like your case is very stale and has been sitting there and really should have been adjudicated by now, we welcome you to reach out to our office and talk to us about filing a mandamus.
Yeah, and I think the other thing to keep in mind is, some folks might have filed their adjustment of status at a company they're no longer at. And so they might have been represented by an attorney that represented that company. If you never sort of tied a knot or how disclosures will get to you, you might want to circle back. So this is also something for our HR folks, having a policy of when an employee departs that has a pending AOS. There's some attorney ethical obligations that the attorney should be handling and communicating to you and the foreign national employee. Sometimes that happens, sometimes that doesn't happen. But if you're a foreign national on this call or listening on YouTube, you'll want to make sure you've got a clear understanding of how any AOS notifications are being sent to you, if they're going to be sent to you. Has the attorney withdrawn from your case? Can the attorney withdraw from your case? Those types of things that you'll want to have ironed out before you move companies. And then as a mobility manager, making that process clear, that exit process clear for your company and for employees departing your company.
Yeah. So we've been able to fix the view of the slides. So I'll let Laura take it back.
Yeah, and that for those attending the call, we'll also send out a copy of the deck. So sorry if you were straining your eyes for some of those Visa Bulletin dates. You'll definitely get a copy of the deck as a someone who's attended, and that it will also be on YouTube in a enlarged format. So if you're watching live, hopefully you're seeing the dates clearly. Should we jump back into the submitted questions? Did I ask you this one already? Will the final action date reach July 2021 for F2A by the end of this fiscal year, Charlie?
The answer would be yes.
Okay. Yay. The next question, does NVC monthly backlog report only count documentarily qualified applicants whose priority dates are current and waiting for an interview, or does it include all applicants who are documentarily qualified? So I think we need a little bit of context about what is this NVC monthly report we're talking about, and then maybe answer the question, Charlie.
Yeah, I'm not sure. I haven't looked at their backlog report in ages. So I don't remember exactly if it is only the cases which are eligible for interview or not. But you know, the report, looking at the report is going to be depressing, and it doesn't really do you any good to look at it in terms of your case. I mean, you know, there may be a backlog at post X and post Y doesn't have a backlog in processing. So I really wouldn't worry too much about this in regards to your particular case. It may just upset you unnecessarily, and looking at it's not going to do you, you're not going to be able to do anything about it. And again, I know that the State Department is actively doing everything they can to reduce the backlog of cases. Again, it's important to remember during the COVID times, most of the posts in the early part of COVID were closed. So their workload was backing up during those COVID times. And then once they came out of the COVID times, they had to catch up on the old cases with new cases coming in, which adds to their workload. And they have limited amounts of staffing. And I know that when I was working, all of the overseas posts, and I'm assuming USCIS as well, were working at peak capacity with the staff that they had available.
So there's actually a good question here that came in live. So they're busy filling out their DS260 forms for EB2, not China or India, at NVC's trigger, right? Because they'll send you the notice. So these cases aren't current. So Charlie, your thoughts on like when they send you the DS260, how soon usually does a case become current?
Well, I'm assuming that they're going to be sending that if whoever requested that submitted that question, if you could shoot real quick what your priority date is. My guess is that's where the person's within the application filing date, they've requested it. They want you to submit all the required documentation so that once you become what is called documentarily complete, if you require certain information, then they can report you to the visa office for consideration of scheduling a visa in the future.
Okay.
You can go to the next slide.
Yeah.
Okay, I want to know the prediction for priority date, December 2014, Indian EB3. I know the standard answer we don't know, but can we get an idea? Like 3 months, 6 months, 1 year? Charlie is there. My expectations are high on prediction.
I would not expect a December 2014 India third preference to be reached in the foreseeable future. 2025, fiscal 2025 or 2026.
Okay.
I wouldn't go out that far, but I would not expect it until at the earliest sometime in 2025.
Perfect. If a Chinese national has both EB5 and EB2 petitions approved, given the extremely lengthy wait for an I-829, would it be better to wait for EB2 for a 2022 priority date, or to be current to file I-485 or file a conditional green card under EB5 conditional now? This one's really going to be case specific. I think this is more for Charina and I to tackle. I mean, as far as predicting the priority date, that's kind of like what your tolerance is and what the strategy is, the strength of those cases. So this one's really difficult to opine on. I think obviously if you're looking for expediency for filing, the strategy would be to file under the EB-5 and you get the benefits of being a green card applicant with a work and travel permit. But there could be other reasons based on strength of case to file the EB-2. So this one, if you want to have a consult, this is a great one to talk to one of our team members. Again, we're experts in EB-5, so we can also weigh the strength of the case if you sign up for a consult with us.
And one other thing, there is an applicant can file in as many preferences as they have entitlement to. So if somebody has the means to file for fifth preference, they can be filed in fifth preference and also in second, and whichever comes up first, they'll get the visa there. So there is no detriment to filing in both if that's an option.
Fair point. Charina, any questions you want to take from the live Q&A?
That last question that I had asked, they said their priority date was 9/15/2022, but they didn't give their categories. I think that's going to be, would you be able to predict that
Yeah,
one?
but if that was if for example that
Oh yeah,
was
they gave EB-2. Sorry, they gave EB-2 all other. Sorry.
all other,
Yeah.
the rest of world application filing date is January 1st, 2023. So that's probably why they received that notice.
Okay, so they
'Cause
probably, so
They
they
want to
could
get them, they want to get
expect it
them in
to
the
be-
pipeline so that they
Okay.
know they're ready. Again, that's where I said, once everybody becomes complete, they're reported to the visa office. Visa office knows if we move the date by 2 weeks, 3 months, it's going to account for this amount of applicants instead of having to rely on an estimate.
So they could be called in for interview the summer of next year.
Yeah.
Yeah.
Just monitor the forward movement of the final action date. But it's important for applicants to, when you are, whether immigration sends an RFE or whatever, a State Department asks you to submit documents, do so in a timely manner. Because if you've submitted all your required documents and the date, if you report them in during December, then February 1st, your date is reached. You would be scheduled, if you've been reported to the visa office as documentarily complete, you could be scheduled for a February interview, assuming your priority date's reached.
Okay. And then just one question, do you predict the Philippines to remain aligned with all chargeability?
Yes, I see no reason why this Philippines would not remain at the all chargeability dates for the foreseeable future.
Okay. I'll pass it back to you, Laura.
Okay, this is a good one. I like this EB1. So in October, why did India EB1 advance from 2012 to 2017, 5-year advancement, while China only advanced 2 weeks, February 1st to February 15th? Does it mean that DOS decided to give all the rest of world unused EB1 numbers to India EB1?
The reason the India EB1 date was put back at 2012 at the end of last year, and the dates retrogressed at the end of last year. When they retrogressed for August or September, the intent of that was to basically stop any future number use because they realized India Employment First Preference had used all the numbers they possibly could. So we're going to draw the line in the sand at 2012. That means nobody else is going to get, no more Indians are going to get numbers that fiscal year. Then on October 1st, when they had the new supply of numbers, they could move the date forward to 2017 and basically recover the ground that had been lost because they had their new supply of visa numbers. And the same would have been for any other where you had a retrogression in August or September and then had a dramatic jump in the date for October.
And yeah, when they're setting dates, to sort of clarify, it's kind of like what they're expecting, they're the sort of allotment month to month, right? And so like they're setting the dates not based on use of other categories at the beginning of the fiscal year. They're setting it based on, we think we have X amount to allot per month based on the annual allotment.
Right. For example, if the annual limit were 12,000, that means if they wanted to use an equal share every month, they could give, they would set a final action date, which would allow 1,000 numbers to be used in October, 1,000 in November, etc. So by the end of September, they would have used all 12,000 numbers. There's a number of variables involved with that. To use 1,000 numbers, you might have to call in 1,500 applicants or 1,200 or whatever, because a certain amount would not appear for their interview or may be refused. So there's a bunch of variables, but the State Department has it down to a science, and they consult with immigration to get information on their expected processing rates. And so they coordinate very well together to try to reduce volatility. And again, that's why I believe dates have not been moving this year, is they want to avoid volatility in the movements at all cost.
Makes sense. Okay, next question. My question is related to country cap, which is 7%, to avoid visa monopolization by a particular country. Despite this rule, how was Dominican Republic issued 14,954 visas out of approximately 26,000 annual visas in F2B category in fiscal year 2023? Thanks, team and Charlie.
There is a 7% cap, the 7%, and that's to avoid a handful of countries. But for this example, there is each preference category, F1, F2A, F2B, F3, and F4, gets a percentage of the per country limit. The per country limit in family is 15,820 numbers divided up among those categories. If numbers are not used in the family third preference, any unused can fall to the family fourth. Any unused family fourth fall up. And I believe we did a chart, showed a chart in last month's, or at one time, we did an employment last month. So any unused third fall to fourth, any unused fourth fall up to family first, which fall down to 2A, which fall down to 2B, resulting in that 14,000 figure. And the reason for this fall up, fall down procedure is to avoid wasting any potential numbers, in this case, in the Dominican Republic. So they were able to use 14,954 out of their 15,820 limit.
So just so I understand, this is like that there were under usage in the other categories for the Dominican Republic?
Right. For example, the fourth preference category, Dominican Republic, would be the limit would be approximately 4,550. If they only used 550 numbers, then 4,000 would fall up to the first. And if they weren't used there, and any first that weren't used, they'd fall down to 2A. And like I said, it's a cascading effect. But the intent is to maximize number use within the per country limit.
So it sounds like maybe this question is really getting at like a misunderstanding of how the visas sort of cycle within the country. Like the Dominican Republic getting these 14,954 in the F2B category was a result of low usage in the Dominican Republics and other family-based categories, not at the expense of other countries.
No, they're not. And the reason being, Dominican Republic is subject to the same final action dates for any other all chargeability country. So the fact that they use this, like you said, is not negatively impacting any other country.
Okay. I think that's what this question's getting at when I read it. And as you're describing it, it's helped clarify that understanding. Thanks.
We have this good question here. Historically, what is the average number of dependents for EB2 all chargeability? Does the Department of State consider this in setting the dates? Like, are they thinking about how many dependents most people have that are going to use the numbers?
The dependent information is reported to the visa office. So when the applicant submits their documentation to the National Visa Center, it will indicate that there is a principal, a spouse, and 2 children. So when that information is reported to the visa office, Charlie's case is documentarily complete. They would report 4 China employment second preference applicants. So they know that up front.
But how about for, is that because on the I-140, people will have to list out that they have dependents? Is that how you gather that information?
Yeah, the information is reported. The one category we were having trouble for a period of time was the employment 5th preference, because originally the petition only requested the information on the principal. So it wasn't until later in the process that we learned of the, that the case actually had, 3 applicants or 4 applicants or whatever. But changes in the form have rectified that problem. So again, it's a relatively easily tracked item in the information.
But let's say you have a priority date from 5 years ago and you're single and you filed your I-140s, your priority dates from 5 years ago, and then you have a spouse and children. That's not really allocated in the estimates then, right? Because you don't know I have a spouse and children now.
But when you file for your adjustment of status, at that point, you would notify them of that information.
So you really are only getting the data when the adjustment's filed.
Yeah.
Okay.
So.
Okay, what's the outlook for F2A? Will the filing dates advance anytime soon, and by how much?
Again, I think there should be steady advancement. I would not be surprised if they get into 2020 or 2021 in the very near future, peaking out sometime in 2023, mid to late 2023 for F2A rest of world.
And then there was a question also about the filing dates. So the filing dates are going to keep moving, yeah, Charlie?
The filing, like I said, I would not expect any forward movement of filing dates before, say, March or April. And I think that unless there's a dramatic, unless the amount of filings is significantly less than anticipated, if so, they may advance them earlier, but there may not be until sometime in the second half of the year. They may be advancing them to start generating demand to be used during the first quarter of fiscal year 2025, knowing that if somebody starts filing their adjustment of status application, say in May or June, there's no way that case, or probably no way that case will be finalized until October or November. So you're starting to gin up demand for next year.
Great. The next 2 questions relate to EB1 China priority date movement, and there's a ton of questions from attendees. So I guess could you just speak to projected EB1 movement for Chinese nationals?
Yeah, I think the point you made about if EB2 applicants are upgrading status, that could put some strain on it. But throughout fiscal 2022 until December of 2020, fiscal 2023, the category was current. And from January through the end of the fiscal year, it was the China first preference date had advanced to February 1st of 2022. So the fact that it's only advanced 3 weeks this fiscal year, that's a little surprising. So I would think that they're going to start advancing it, given the fact that unless you have the upgrades you mentioned from EB2, much or the significant portion of the EB1 demand earlier than February of 2022 should have been taken care of in earlier years.
Okay, so that's positive, in that there's likely to be some movement in these next couple quarters this fiscal year for Chinese EB1.
Yeah, and I would expect 2 to 3 weeks. if it held, the fact that it's held for so long, that could increase to, 4 to 6 weeks. Just depends on the comfort level of the State Department in their consultations with immigration on potential number use.
And when you're saying 4 to 6 weeks, for those on the line, that's for like the final action date.
Yeah.
Okay. And so if it's 4 to 6 weeks on the final action date, it perhaps could be potentially more for dates for filing.
It's going to use numbers based on the applicants that are already filing. And that's,
yeah.
like I said, that's the good thing. People are going in and filing. Somebody that, if that filed late last fiscal year based on or excuse me, early this fiscal year, once their case gets reported. So I think there's positive. I think there should be good hope in all the China categories for forward movement in the coming months.
Okay, cool. I think I addressed most of those questions. There were a ton on.
There's one question on EB3 rest of world and the movement there. So if they have an August 2022 priority date EB3 rest of world, when will it be current?
I think in August of 2022, maybe in sometime in the summer, I would expect that to be reached.
And then if someone has a February 1, 2023, then it's going to probably be the next fiscal year.
I mean, I would think something in the next fiscal year for somebody with that type of date, a February of 2023 date.
And then for EB2?
EB2, I think that the date, it should be starting to advance, 1 or 2 weeks per month, I would think.
Yeah, so for August 12, 2022, EB2 rest of world, it's probably looking good for you, right?
Yeah, I mean, the date there was current until last December. Then it was in November until March. Then it was back to backed up. So, I mean, at this point, they're recovering a lot of ground that was covered in earlier fiscal years. And this is one of the,
yeah.
Well, and the one thing people need to remember, everybody got very comfortable with the rapid forward movements of 2022 and 2023 and a little bit in 21. Those were extraordinarily high annual limits that were all-time highs and a direct result of the negative impact COVID had on overseas processing of family-sponsored cases. For example, there were 140,000 unused family numbers in fiscal 2021, increasing the normal 140,000 employment limit up to 281,000, effectively doubling it for fiscal 2022. So now for fiscal 2024 and going forward, we're going back to what is more normal annual limits for the employment categories. So people should be this is going to be the new norm. We're getting back to the way things were pre-COVID.
And then this one, is there any chance that Brazil, Iran, Korea will get their own chargeability given that they're getting close to the 7% limit?
No. The only countries, historically, which have been oversubscribed are China, India, Mexico, and the Philippines. And being oversubscribed with those countries means that they have one or more final action dates, which is earlier than the all chargeability area dates. So for those countries you mentioned, I would not have any concern with the numbers. One thing people can look for is the State Department on an annual basis. They publish on the immigrant statistics page under hot topics. They have a listing of the National Visa Center waiting list as of November 1st. It'll be 2023. I would expect that if time constraints, if they're able to prepare the report, they may post that in mid-December. potentially earlier if their workload permits it, but mid-December to the first week of January. And you could look there. It's a very nice detailed report, breaks it out by the family-sponsored preferences and employments, showing the top countries of demand. And if you were born in Iran or Brazil or Korea, you could look and see in your particular chargeability, is there an excessive amount of demand? But again, if you're not born in China, India, Mexico, or the Philippines, you have nothing to really worry about.
Should we take one or two more? This is an interesting one. Charlie, do you see the filing date for EB3 rest of world moving slightly, given that the DOL current processing December 2022 perms, which would mean B, not much new I-485 would be filed with the current filing date? Or is it a case that they would have enough cases so they'll just stop using that chart?
Since I don't have access to their data, this is going to be something where the State Department and Immigration Service, in consultation with Department of Labor, would have to figure that out and figure, do we need to advance the date? Do we need to, can we hold it or whatever? But that would require consultation between the three agencies.
Yeah, and then just to kind of clarify, filing a perm or a perm being adjudicated, the USCIS has no idea if that's been approved or not. So like until an I-140 has been filed, USCIS is not notified of that sort of demand for EB2 or EB3. And so because of the perm processing timelines being about a year, it is kind of delaying the notification to USCIS of EB2 or EB3 demand in any category because it's so long to file the I-140. So I'm not sure that we're really answering that question. We don't really know what they're getting at, but USCIS is not notified of the EB2 or EB3 until an I-140 has been filed. What's next? Charlie, do you think dates of filing would not move for the next quarter for EB3? I think Charlie kind of answered that one, that we do think.
I really would not expect any forward movement in the application filing dates before March at the earliest, probably April or beyond. Again, the dates they established in October and announced were their belief that those dates would provide enough demand to utilize all of the numbers under the fiscal 2024 annual limit. They would only advance them at some point if their estimates were drastically low in terms of the amount of filings, or if sometime in the second half of the year, they want to start moving them to start, and this would be primarily on the family side, to generate demand going into the first quarter of the next fiscal year.
Sounds good. And that brings us to just about time. So thanks for hanging with us. Make sure you like and subscribe us on YouTube. We'll be posting the video shortly for all of us to take a look there.
Thank you, Charlie, Laura.
All right.
Thanks, Charlie. Thank
Bye.
you.
Take care.
Thank you.
Bye.
Bye.